What were your subjects in LLB?
Sir, in LLB, I studied all the subjects that were mandated by the UGC.
CPC is the procedure laid down for the trial of the suit. Do you know it?
Procedure laid down for the trial of the suit. Yes, sir.
Hmm.
I
Yeah.
know it.
Yes. Order to deal with the frame of the suit. How a suit is to be framed. You
Sir,
know,
sorry, sir.
order to relinquishment of claim. You know it?
Yes, sir.
What is that? Relinquishment of
The
claim.
Rule 2 of Order 2 states that if uh, any claim or any relief which has not been sought by the plaintiff or any party before the court, then that relief will be deemed to be relinquished by the court and it cannot be sought again.
Yes, if a petitioner plaintiff doesn't claim a relief, it means he had given it up, relinquished it. Otherwise,
Yes, sir.
it is meant for bringing a suit to the jurisdiction of a particular court.
Yes, sir.
Suppose I have a claim of 3 lakh, more than 3 lakh, but a local court doesn't have that jurisdiction. Then I can give up the some relief to bring it to the jurisdiction of the local court. Am I right?
Yes, sir. It is possible. Uh, Again, because of the application of Rule 2, then that relief cannot be brought
Yes.
up in that
All
jurisdiction.
right. All right. What is enlargement of time? Have you heard of it? Enlargement of time.
Yes, sir. Yes, sir. Under CPC, sir, under the inherent powers of a civil court, the CPC provides as a power to civil court to enhance the power, to enhance the time limit for any submission that has to be made by the party in order to achieve complete end of justice.
Yes, it is not. It is statutory power. It is different section. 151 is inherent power. But if time is given by a court to execute a particular job in a particular time, but the party is unable to do it, then on the
Yes,
prayer of party, court can enlarge the time.
yes, sir.
Okay.
This is under
Yes.
Section 148 of Civil Procedure Code.
Yes. It is independent power apart from the inherent power.
Yes, sir.
So, what is the whole purpose of CPC? Do you agree that the whole purpose of CPC is to dispose a case on merit?
So CPC provides the procedure that has to be followed by a civil court in civil matters that arise before it. It gives procedural laws and
Yes,
it does not deal into substantive matters that
yes. If
appears
suppose
before the court.
if a defendant is proceeding ex parte, if defendant is proceeding ex parte due to non appearance, and he appears later on, or his defense is struck off, and thereafter he applies that his defense may be allowed. Would you grant it, or would you prefer to let the case proceed ex parte?
So, Rule 13 of Order 9 provides that if any order that has been passed by the civil court ex parte because of non-appearance of the defendant at a later
Yes.
point, whenever the defendant appears before the court, then if the court is satisfied that his non-appearance was out of a reasonable cause, in that case, the court can allow the defendant to proceed with his arguments.
Yes, he will have to show a sufficient cause for that.
Yes, sir. Sufficient cause has to be shown. Yes,
Yes.
sir.
That's why I am saying the whole purpose of CPC is that a case should be decided on merit instead of technical grounds.
Yes, sir. I
Hmm?
agree with.
Okay. What do you mean by local commissioner? Local
Sir,
commissioner.
local commissions is sent by the civil court to inquire into the matter that has appeared before it. It can be commissions can be issued for various reasons. For example, scientific research or judging the property, etc. It
Okay.
Yes.
Under which section of order? Under which order of the CPC? You know it?
Sir,
Okay.
sir, I'm not able to recall. I think it is section 58, but I'm
Or
not able
it
to
is not under
recall.
section, it is under order 26.
Sorry, sir.
Or,
Sorry, sir.
or okay, doesn't matter. I'm happy that you admit that you don't know it.
Sir, I
Under
read it.
which,
I could not recall it.
okay, very good, very good. Under which section commercial cases are filed in under CPC? Have you heard of
Uh,
commercial case under CPC?
yes, sir. Yes, sir.
Order 37
Uh,
suits.
sir,
Order 37.
yes, sir. Order 37 provides for summary suits.
Yes,
Summary
yes.
suit. Yes, sir.
Of commercial cases only, based on checks, hundi, etc.
Yes, yes, sir.
Okay, okay,
Sorry, sir.
okay.
I could not recall the kinds of cases which could be issued.
What are you doing at present? Are you practicing or you are just
Sir, I am not practicing at the moment. I finished my graduation in 2020 and I worked with EY for 1 year after that. I recently completed my master's in June 2024.
in which subject?
Sir, did it from NLU Delhi, so there is no particular specialization. The bifurcation was based on public laws or commercial laws, so I did my master's in public laws.
Public laws. Okay, okay. What is res judicata?
The res judicata is a provision laid down under Code of Civil Procedure, under Section 11. It states that if a matter has already been decided by the civil court of
Hmm.
competent jurisdiction, it may not be brought again before the court another time. There are certain conditions which have to be met, that
Mm-hmm.
the case was between the same parties and same right under same rights and same title, and it
Okay,
related to the same subject matter. So the idea being that once the civil court has finally adjudicated upon a matter, then there is no reasonable ground to entertain that suit.
okay. Now you are trying to join judiciary. What do you think of
Yes.
judiciary? Do you hear of any corruption in judiciary? What is your perception of that?
Sir, I believe the laws in our country, the Supreme Court guidelines, as well as the legislative uh, uh, provisions which have been provided are very sufficient in nature. And whenever some instances like these arise, the laws are sufficient to deal with such one or two incidents.
No, do you think that public perception is adverse or it is in favor of judiciary?
Sir, overall, I believe that the public perception is in favor of judiciary only, because a lot of times judiciary proves as an material instrument for upholding the democratic values of the society.
All right. No more questions from my side. Now my colleague will put questions.
Thank you, sir.
Hello, Bhavya. आप पूछ लो. Continue. Hello, Bhavya. I am audible.
Hello, sir. Yes, sir, you are audible.
Okay. So, what is the main difference between inquiry, trial, and investigation?
Sir, investigation refers to the judicial not judicial proceedings. These are the proceedings conducted by a police officer at the time of institution of an FIR. Once the FIR is registered, the police has been mandated under CRPC to conduct investigation for that case. So any proceedings in that regard which are done by the police is called investigation. Inquiry is a term for judicial proceedings which are conducted at the order of a magistrate. In that regard, the magistrate himself can conduct an inquiry, or he can order someone else to conduct it. The trial is refers to the judicial proceedings in which the guilt of the accused is determined. It can either result in acquittal of the accused or punishment of the accused.
Okay. So, whether there is any chance of investigation and inquiry overlapping?
No, sir. Under Code of Criminal Procedure, there is the inquiry or investigation cannot overlap. Investigation has to be conducted by police, and only after the investigation is completed, then the magistrate can give a further order regarding the inquiry. So they cannot overlap.
Okay. Did you heard about the concept of hostile witness?
Yes, sir.
So what is hostile witness?
Hostile. So, witness refers to a situation where a witness has been called by a party before the court of law to provide a testimony in their favor, but after getting to the court, they do not give that testimony in the favor of the party called and gives a testimony which is adverse to the party which has called the witness.
Okay. Confessions are defined under Indian Evidence Act or not?
So, confessions are defined under Indian Evidence Act. Sections 24 to 31 of the Indian Evidence Act talk about confessions.
What is Section 89 of CPC?
So, Section 89 of Code of Civil Procedure provides that once a case before the civil court, then the court can order the party by means of arbitration, conciliation, lok adalats, or mediation. This was brought through an amendment later on. It was not originally there.
So by which amendment the legislature added this provision in Civil Procedure Code?
So I think it was 2001 amendment.
Okay, so in every civil case, the procedure of Section 89 is mandatory.
Uh, it is not mandatory in every case. There are certain cases where court should not order resolution under the provisions of Section 89. But in majority of cases, it should be preferred that alternate dispute resolution mechanisms are looked into.
Okay, if the state set up the civil code, then what is the need of this section?
Sir, because judiciary is already burdened with a lot of pendency, and many a times when a case reaches the court, it takes decades to decide the matter. Although now things are changing and courts are able to pronounce judgments quickly, but in order to address this pendency of justice, this alternate dispute resolution mechanism was brought into place so that if parties are willing, they can opt for quick disposal of their dispute.
Okay. Now, over from my side, Apurva.
Hello, Bhavya. Is it Bhavya or it is it Bhavya?
Bhavya, ma'am.
Bhavya, okay. So can you tell me about the current status of right to die in India, along with the recent landmark judgments?
Ma'am, right to die is not inherently a part of Article 21 of the Constitution. This Supreme Court had laid down in the court has ruled this in several judgments. However, recently, in the case of Aruna Shanbhog, the Supreme Court had laid down that if uh, the state of the petitioner is such that on the grounds of mercy petition, then a right to uh, die with medical assistance can be allowed and looking on a case-to-case basis if it is absolutely necessary.
So is active euthanasia legalized in India right now?
No, ma'am, active euthanasia is not legalized. Passive euthanasia is allowed. It was allowed in the case of Aruna Shanbhog.
Okay. Now that we are talking about right to die, what is the status of attempt to suicide as we speak right now? Is it a punishable offense?
Ma'am, attempt to suicide was decriminalized by the Supreme Court. Uh, I'm not sure. I'm sorry. I currently have not checked the provisions of DNS on what it says about that.
No
Sorry,
problem.
ma'am.
No problem. Can you tell me a difference between motive and intention, along with illustrations, not by definition? Just one illustration each to for motive and one for intention.
Ma'am, motive refers to the mindset,
We can
the
skip
reasons
the
behind.
definitional aspect. We can skip the definitional aspect. I just need one example for motive and one for intention.
Okay, ma'am. For example, if the husband has killed his wife, and it is found out that the wife was having an extramarital affair. So this state of affair could be held as the motive. And if the husband has been found in possession of a weapon with which he killed, or maybe he purchased poison, for example, so that could be said that it was the intent to kill his wife.
But procuring poison is
With
also
the intent
preparation.
to kill his wife.
Procuring a poison is preparation, right? So it is like one stage ahead of intention.
Yes, ma'am.
No problem.
I
So you
agree
just
with that, ma'am.
just a few minutes back, you defined hostile witness. What is the evidentiary value of hostile witness? Is it completely inadmissible, or there can be certain part of it that can be held admissible by the court?
Ma'am, it is up to the court to decide. If the court believes that certain parts of the testimony which has been given by an hostile witness, they can admit it in favor of either party.
Okay. So how do you prioritize your own emotional well-being in your day-to-day life? This is like a general question.
Ma'am, I believe incorporating certain activities into the daily routine can be very good for mental health. I try to take out 1 hour for walk and physical fitness. I try to take out time for spending time with my family. And I think doing 1 or 2 hours of recreational activities every day is good for every individual.
Are you usually updated with the legal current affairs and the judgments?
Ma'am, I try to be. Uh, Whenever I get the time, I do look up. I read on live law, etc.
Is there any recent landmark judgment that stands out for you in terms of progression of country's state?
Ma'am, recently, Supreme Court has allowed sub-classification of scheduled castes and scheduled tribes in order to ensure that the benefits which are provided by states for such marginalized communities, they are made available to people who actually require them. And by excluding certain creamy layer classes which have already availed these benefits previously, the court has, I think, uh, created more efficiency for these provisions.
Okay. One last question from my side. Recently, Supreme Court also launched a book for specially abled people regarding the terms that a lawyer or a judge can use. Do you know about that handbook?
Ma'am, I have read about it. I cannot recall the name at the moment, but the idea was to call them with names which are not derogatory. For example, the term physically challenged was used, or handicapped was used quite often. So now it is being changed to challenged and not handicapped. The Vyanjan is also widely used currently.
Okay. That's all from my side.